framework or the structure, we looked at and if I'm not too clear, please do let me know. If we look at the concept underlying the constitutional provisions, concept underlying constitutional law, looked more particularly at the entire question of equality. And now we're looking at the entire question of the right to life question as well. Again, it's useful to maybe just look at the text itself. I'm going to take you through the text again. Yeah, I'm going to do the share again. You can see the text of the Constitution now, as you.
Yes, Arvind, we can.
Okay.
This is showing Article 359.
Yeah, perfect. Yeah, perfect. I'll just get to the
21. Yeah.
21. Yeah. So the point which we made is we have to understand the Constitution as a relationship of different parts, as it were. And one specific way of reading law is you look at the relationship between different articles, as it were. And we've looked at again equality. Look at the headings of the fundamental rights chapter, right? The right to equality is, we have to look at the relationship in 14, 15, 16, 17, and 18. And we've addressed the relationship, if you remember, between 14, 15, 15.4, 16.4, and 17. And we looked at the relationship in prohibition of untouchability and the concept of, say, formal equality in 14 and substantive equality in 15.4 and 16.4. That's broadly, I mean, again, very broadly, synoptically, what we did with respect to the right to equality. Now, and then when we came, the other section we looked at, of course, in some detail under the right to freedom is 19, right? And we looked at in particular the relationship between 19.1, which is the speech question, and 19C, which is the assembly question, and B, which is the association question. So A, B, and C become very, very central and very important in understanding one dimension of freedom, which is 19. Now we'll also look at hopefully we'll get time to look at also 20 and 22. But in this case, we want to focus a little more strongly on 21, right? And 21, look at the language again. It's the in a sense, if you are thinking of it purely as the length of the text, it's the simplest provision, right? It's just one line. No person shall be deprived of his life or personal liberty, except according to procedure established by law, right? But there's a lot involved in each of these words, in each of these concepts. What do you mean by life? What do you mean by personal liberty? How is personal liberty different from personal liberty alone? And of course, most importantly, what do you mean by procedure established by law, right? These are the concepts which underlie this discussion as far as 21 is concerned. And just quick, I think it's useful to know this, that we keep referring back to the Constituent Assembly debates. And if you go back to the Constituent Assembly debates, there's a very strong or very intense discussion on this language of procedure established by law. And you think of it in a commonsensical way, right? Why are people so concerned by this? Precisely because of this. It says no person shall be deprived of his life or personal liberty, which means that persons can be deprived of their life or personal liberty. That is, except according to procedure established by law. If you have a procedure established by law, then you can deprive a person of life or personal liberty. That's what the article on the face of it says, right? Then, of course, the big question or the challenging question is, what's the meaning of a provision which allows for you to take away life or personal liberty as long as you have a law? That's the big question which comes up in the Constituent Assembly debates. People are very, very dissatisfied with this article, and they want the language. For example, the language proposed: there is no person deprived of life or personal liberty except according to due process of law. And the difference between procedure established by law and due process of law is, when you say due process of law, the law should in effect be substantively fair and just. Whereas procedure is procedure. That is, there must be certain procedure by which the law establishes, then the law is fine. But is there a requirement for the law to be substantially just? That's the discussion or debate which happens in the Constituent Assembly. And finally, they go with the language of procedure established by law, which is a much narrower frame than due process of law. Okay? And again, you go back to the Constituent Assembly debates, you realize that there's one place where often Ambedkar, you get a sense of very clear, very strong opinions on various provisions, as it were. On this point, on this debate on procedure established by law, he actually, in a very brilliant fashion, lays out both the positives and the negatives of having procedure established by law, having due process of law. And finally,
Arvind, if I
Yeah.
may,
please,
before we
come
go into this procedure established and due process, there was one thing, if we can, why don't you just show 19 once
Yeah.
and see the difference in language? Can anybody kind of come back on what is the difference in the language that you see? How does 19 read and how does 21 read? Can anybody comment on it? How does 19 begin?
All citizens shall have the right. I think it's negative versus
Yeah,
positive.
go back to 21. Yeah, that's
yeah.
right. Now, why do you
Hmm.
think anybody, any
Also
take on,
citizens versus persons.
pardon?
Also citizen versus person.
Now, and negative and now, why do you think this is worded negatively?
As to impose some restrictions to make it clear.
No, but so in the earlier one, they said you shall have, if all citizens shall have this. Here they say you will not be deprived of this. So do you think that makes any difference?
They are ensuring the minimum.
Okay, anything else? One
There are no
article.
exceptions.
Yeah, please.
There are no exceptions in 21. Like in 19, we saw in certain situations, it cannot be like 19 cannot be provided, but 21, I feel there are no exceptions. That's why maybe it is worded like this.
But no. So, but here the article is conferring. They are saying it's giving you these rights.
Hmm.
But in 21, what does it say? 19.1 is giving you rights. 19.2 is limiting those rights.
Yeah,
Now, 21 is not talking about giving you life and liberty.
because those are fundamental rights which cannot be taken away unless there is a strong cause, right?
That
You don't
is
have to write it.
exactly. So I think if you recall the earlier when we read the preamble, this is what Ambedkar, when I think Arvind took you all through Ambedkar's speech, he says, I mean, when he critiques Nehru's intervention, the objectives, he says, what is this big deal that you're talking about? This is something part of the Universal Declaration of Human Rights. So in a way, if you look at 21, what does this mean? That all of us, we don't need the constitution, because you will see how the law developed later on, which Arvind will take you today. But when it is starting with the negative, that you will not be deprived of it, deprived of your life or liberty, the inference is that we are all anyway born with it, isn't it? Like unlike Article 19, where the state, the citizen shall have, you shall have right to speech, you will have right to form associations. But here it does not say you shall have right to life and liberty, because the assumption is that everybody anyway has it. But they are now saying you cannot be deprived of it, except according to procedure established by law. So just keep this in mind, the wording and how later on this got, developed in terms of, I think the dissenting judgment of Justice Khanna more or less kind of talks about this, that, life and liberty is not something which somebody confers, but it is inherent in all human beings, like the Universal Declaration. Yeah, Arvind, yeah, please continue.
Thanks. So, Sala's point, again, it's a very important point, which is, does the Constitution confer rights or does it confirm rights? Do you have rights inherently? Do you have rights by virtue of being born? Again, you go back to the UDHR, right? What is the language? The all persons are born free and equal in dignity and rights. If you're born free and equal in dignity and rights, then the state can't be conferring on you, no, the right to life or the right to personal liberty. You have it because of the fact that you're born and the fact that you're human. Right? That's broadly the argument which underlies the 21 clause. Right? Okay. So that's the debate, the Ambedkar debate, which we don't have time to go into, but please look at it in the Constitutional Assembly debates, where he finally concludes on this debate of procedure established by law, due process of law. He says, see, you're between what he calls a Scylla and a Charybdis, between two Greek monsters. So I can't make up my mind. He literally says that, right? I can't make up my mind. I leave it to the House to decide whatever way it sees fit, whether it should be procedure established by law or due process of law. So there's a way in which Ambedkar is not giving you an answer on the 21 question in particular. Yeah. Okay. So that's one part of the. Okay. One more point of debate is the question of personal, right? What does the word personal do when you attach it to the question of liberty? Again, very important because there's also the freedom of contract, right? Liberty to contract in the United States context. And so the framers were very cognizant of this point, and they were very clear that when they refer to liberty, you meant the liberty of the individual subject, of the individual person, and your personal liberty, your rights of which come to the individual human being, not the contractual right. Right? So again, they qualified the word liberty by the word personal. So you get a sense of how each of these words is quite important, right? And what is the distinction between life and liberty? Again, we'll look at this concept as well in a little while, right? Okay. So you've got a sense of where 21 stands in this entire uh, constitutional frame, as it were. And of course, I mean, when you say life, you can imagine that it's maybe perhaps one of the most important or the most important right, which the Constitution should protect or should protect. Yep, that's the way one would think of it. And I want to, of course, the readings you already have. And when Vinudha said it's difficult reading, I agree. It is difficult reading. And I think the purpose of reading it, whatever extent you read it, is so that the class makes a little more sense, right? So you have a little more sense or understanding of what is going on. Sometimes you read many times to get a sense of what the judgment is actually saying. So don't take it. It is difficult, right? And sometimes you have to persist with the difficulty, and things will fall into place at some point in time. Okay, so let's get to the point of discussion on 21 in this class, which is the judgment on the emergency, right? To do that, of course, we have a little bit of background on what is the emergency. Emergency is, of course, in 1975, you have the declaration of the emergency, and constitutionally declared under 352, which is the provision which we can look at. But in the context of, again, the president can proclaim an emergency in the context of, in this case, of what the language is, internal disturbance. Right? And what is the internal disturbance which the Indira Gandhi regime found, for which she felt she had to declare an emergency, goes back again to the struggles at that moment in time. The Jayaprakash Narayan's call for total revolution, the Navnirman movement in Gujarat, and the range of protests and demonstrations were happening throughout India at that moment in time against the various dimensions of the actions of the Indira Gandhi government. That's one part of it, right? There's a level of protest and demonstration going on. But again, protest and demonstration by itself may not necessarily trigger, right, a government to impose an emergency. There's one more dimension to JP's call. One of JP's call is he calls on the army and the police and the security forces to disobey the orders of the state, saying that they're illegitimate orders or they're orders which lack morality. Right? So there's a way in which again, what is the state, right? One core dimension of the state is its control over armed forces or control over the legitimate sources of violence. And you have a threat to your control over sources of violence or legitimate violence when somebody issues a call to the army and to the military saying disobey the orders of this particular government because this government is illegitimate. Again, but there's no evidence that people disobeyed the orders, so that's one part of it. Right? But the other part of the threat which the Indira Gandhi regime saw again came from the judiciary. And there's one the background again. We discussed a little bit of this. Is you had in 1973 you had the Keshavananda Bharati judgment, right? It puts a bit of a roadblock in the path of the state. Because what does it say? It tells the Indira Gandhi regime that you can amend the constitution. Of course, you can, but you cannot amend the basic structure. You can't amend features which are part of the basic structure of the Indian constitution. So, in a sense, you're telling the Indira Gandhi regime that limitations, the implied limitations to the power of parliament to amend, repeal, or vary any part of the framework of the constitution. So there's a way in which the power of the Indira Gandhi regime is sought to be controlled again by the judiciary. Right? That's one part of it. And of course, the other big development is the decision of the Allahabad High Court, where they strike down the election of the Prime Minister. They ruled that the Prime Minister's election was invalid and violates the existing legal framework. Right? That matter goes on appeal to the Supreme Court. Indira Gandhi asks for a stay. The then vacation judge Krishna grants a conditional stay, allows her to function, allows her to the stay. The stay is not granted unconditionally, but there's a condition to that particular stay. That's not good enough as far as Indira Gandhi is concerned. And the next day or the day after, I don't remember exactly when, but quite very, very soon, she declares, she prevails. Again, not she. Who can proclaim the emergency? The president. The president signs the proclamation of emergency. It's a great cartoon. I wish I had. Now that we're thinking about it reminds me, which if we find it online, we can show it. The cartoon has basically Fakhruddin Ali Ahmad in his shower, not in his shower, in his in the bathtub, exactly, the bathtub. And then the proclamation emergency comes to and he signs it like that, right? Sitting in the bathtub. Basically, being the president is the plaything of the executive. But the president is not supposed to be the plaything of the executive. That's the point which the cartoon is really making. But if you find it, we'll send that to you. Anyway, so he signs the emergency proclamation and the emergency comes into force, right? What is the problem with the emergency? Again, you ask that question, the range of sources you can go to. And there's a very good account of the impact of the emergency on two core issues, which is family planning or mass. I think put differently, family planning puts it very innocuously. Is mass sterilization is one kind of a dimension. Second is of course mass demolitions. Third is arrests. Right, three big consequences. Fourth is constitutional and legal amendments. Four broad kind of shifts which the emergency brings about. But perhaps, right? I mean, okay, we'll do two quick points on this. One is the sterilizations which follow. Again, for those who are, I mean, I'm sure that many people who are much older than me who have a good sense of the emergency and what happened during the emergency. I'm sure there are also many people much younger than me who have no idea of the emergency. So, my suggestion is if you get a chance, read Rohit Mistri's The Fine Balance, which is a wonderful fictional account, right, of what happened during the emergency. Or if you have a taste for more theoretical work, read Emma Tarlow's Unsettling Memory on the emergency. Two very important, very useful books to understand what the emergency meant, right? One point, of course, is and if you're even more interested in getting an understanding, go to the Shah Commission. Right? The Shah Commission set up after the emergency was revoked, which documents in really powerful detail what the abuses which happened during the emergency. Right? So one is the entire question of mass sterilizations, where you were given targets. Each state set itself targets, say 1 lakh sterilizations a month. The targets go down the administrative hierarchy, and finally the officer goes around getting people, just arbitrarily bundling people into the into the into vans and vans and taking them to the to sterilization centers, as it were, right? So there's a kind of a mass violation which happens. Shantan, is this clearer now?
Yes, Arvind, much better. Thanks.
Okay. Okay. So I think I realized I end up going a little faster. So I'll just keep to my a slower pace, as it were, right? And I speak a little louder. So maybe that will clear the picture. Yeah. So that's one part of it, mass sterilizations, right? And we can get greater details on that in the three sources I referred to, right? The second big question, particularly in North India, in Delhi. I mean, if you look at, I think the inner ring road in Delhi, right? Today we have an inner ring road in Delhi because of the demolitions of slums which happened in that time period. Again, that's a big violation of the right to housing, which happened during the emergency. And the third one, which I think everybody recognizes and knows as the signature of the emergency, is mass arbitrary arrests. Who are the people arrested? People arrested include political leaders, that is right from Vajpayee and Advani to apart from the CPI to every other political spectrum were arrested, right, during the emergency. Political leaders, trade unionists, student activists. These were the people who were arrested during the emergency in large numbers. Over 1 lakh people were arrested during the emergency. Again, arrest is not just arrest. There's one very powerful story, which again, those our friends from Kerala will know this, is the story of this young man called Rajan, who was again affiliated with the communist movement, and he was picked up from then I think NIT Thrissur, picked up from NIT Thrissur and taken to a police camp and tortured and finally killed. And there's a very moving again book by his father about the search for Rajan, right? And search for Rajan through the camps, as it were. Why again there's a link in this, because in the Rajan case, for the first time, the Kerala High Court allowed for even the taking of evidence, and this was cited as a precedent by uh, by Justice Chandru when he was making his arguments, in the case of the Adivasi who was picked up or arrested. So you see a connecting link between this judgment and the judgment which finally was authored by not authored, by Justice Chandru argued for the Adivasi who was arrested and picked up. So that's a signature tune of the emergency.
Sir, Arvind is referring to the Jai Bhim.
Yeah.
Jai Bhim movie. So maybe that is the connection that people will understand.
Yeah. Please, again, please look up. If you've seen the movie, you'll remember, right? The fact of the trial happening in the High Court, the evidence being taken, etc. Right? And how does this happen? Normally, the High Court doesn't go into the questions of fact, but it happens because of the precedent which is cited in the Rajan case, as it were. And today the Rajan the college has a festival in honor of remembering Rajan, as it were. So there's a range of very very interesting ways in which his memory has been sort of be taken forward. But yeah, that's broadly, okay, roughly what happens during the emergency. How do people react to the emergency when it's going on, when it's ongoing? This is a very important point, because emergency, right, apart from these violations, also comes with a very strong censorship regime. So there's a way in which either many people don't know what's going on, and many more people are scared that we don't want to know what's going on. So there's a little bit of there's a lot of silence which follows the declaration of emergency. Again, there's a writer from Balraj Puri who says that even Mrs. Gandhi was shocked by the silence which greeted the declaration of the emergency. Till that time, the protests and demonstrations, suddenly JP was mobilizing thousands of people. Everything just went silent under the weight of oppression or the weight of fear, as it were. Right? So there's a way in which the entire thing of the vibrant civil society, the vibrant political society in India was completely crushed by the arbitrary and mass arrests, point one, and by the sense of fear, which the declaration of emergency had as far as the range of people were concerned. So in a sense, right, you think about it, right? You're in the middle of the emergency. You can't talk about the emergency because of the media censorship. The people who could normally raise the voice, many of them are in jail, and you know you can't protest because your right to protest has been taken away. What do you do then? Right? It's almost like you're confined in all sides, as it were. And one, of course, what you do is you go to the courts. Right? You go to, again, what Vinitha is referring to, you file a habeas corpus petition in the High Court asking that the person arrested be produced before the court, right? Which is the habeas corpus petition. Again, there's a film which please do have. I wish we could. I should put that as well in, but I'll we'll see if we can find it. There's a film on Kannabiran. We read the piece by him last time. It's called The Advocate, right? It's available online. Please see the film. And Kannabiran is also talking about the declaration of emergency, right? And it's a very, very beautiful, very moving part where he and his wife, Vasant Kannabiran, are in conversation on the emergency. And then he says, right? He says, I filed over 200. She said, and he doesn't say it. His wife says that Kanna filed over 200 petitions on people who were detained under the Maintenance of Internal Security Act during the emergency. And she says there's always that suspicion, always that fear that one day he could get arrested. He would file for a petition, could one day get arrested. And so the point that she makes then is she says, I asked him, if you get arrested, you tell me, what should I do? Because you appear for all these people. What do I do? So Kanna thinks, and finally says, she said he could come up with an answer. And finally he says, there's one person, he's not a man of great courage, but he's very fond of me. And he will do something. He'll find a lawyer, find somebody to represent, you get in touch with him. And the day after that, Kanna says that I was walking in the High Court corridor, and that guy who was in front of me just turned around and looked the other side. So the point being, what happens in an emergency is a sense of fear where others' normal bonds of friendship are completely destroyed. Right? This guy who's otherwise a friend, who otherwise do what Kanna asked him to do or worked with Kanna, suddenly said, I will have nothing to do with you because I have to safeguard my own family or my own interests, as it were. I can't be seen with you, right? So you get a sense again of the sense of fear which happened. But what happens, right? In spite of that, right? In spite of that, thanks, Shantan, that's it. I think also if I remember, the emergency part, if you can find it, is around 20 minutes, around the 20-minute mark. If you find it, we can play the short extract. Where
Sure, I'll look into it, Arvind, sure.
Yeah, okay. 20 minutes, part A. Okay, so what these petitions are filed, right? And what happens in these petitions, right? Again, it's very, very interesting that what are the petitions saying? The petitions are not saying that my right to life is taken away, or not saying that there's some my great liberties have been violated, etc. They're making a very simple point. They think you've arrested me under what we call a draconian law, which is the Maintenance of Internal Security Act, which is a preventive detention law, where the government doesn't have to show any cause for they're just satisfied that the person arrested is a threat to national security. Then you arrest the person. The person's not done anything. You just think, right? I, as the government, think that you are a threat to national security. I preventively detain you. Again, the language of preventive detention, right? You know, I haven't done anything, but you may do something, or I have an apprehension you may do something. Therefore, I'm arresting you. Therefore, I'm detaining you. Right? That's the law. So, under the Maintenance of Internal Security Act, all these guys, Vajpayee, Advani, Madhu Dandavate, all of them are picked up and arrested because the government, or we'll be a little more specific on this point, the government is very, again, in terms of legal language, very vague. It's not government. If you read the Maintenance of Internal Security Act, it specifies, right? Who are the people who can issue the detention order as specific as that. It will be the district collector, district commissioner, it will be the commissioner of police, a range of authorities that I've mentioned as the ones who can issue the detaining order. Right? How do you know that they're the ones who have detained? I know that they're the ones who have detained and they signed the detention order. So all the petitions filed in the various high courts challenging detention are saying the detention order is bona fide or the detention order is incomplete or there's no compliance with the Maintenance Internal Security Act. By which I mean that if the detention can be done by somebody who's a commissioner of police, then at the bottom of the page, bottom of the detention order, the commissioner of police must sign. If the detention order there's no signature of the commissioner of police, then as far as you're concerned, that the statute is not complied with, right? No great arguments on constitutional law, but you just say the statute is not complied with. This draconian law, which we've been complaining about forever, you're not even complied with that particular law. Right? That's the argument put forward. So, 9 high courts, actually, in the midst of the emergency, in the midst of the sense of fear, etc., they actually what they do is they strike down the detention of those detained, saying the detention order is not complied with. So interesting, right? In terms of the sense of all this fear one is talking about, but 9 high courts have had this courage, to say that actually we agree you may have the right to detain, but your detention order must comply with rule of law. It can't go outside law. So that's the argument which 9 high courts take, as it were, and then the matter comes before the Supreme Court, right? And the arguments go on before the Supreme Court. Here, I'll just show you again a short extract again from very interestingly, Justice. You have the video, okay? Fine, show the video. That'll be great. Yeah.
Okay, I'll just share my screen. You might have to guide me a little bit to sort of figure out where it is. I think it should be this one.
20. Little further on.
ఒక కేసులో విప్లవ రచయితలు 6 ఉన్నారు. చివరికి ఎంతంటే టెలిఫోన్ డైరెక్టరీలో కూడా విప్లవ రచయితల కుట్ర కేసు అని దాని ఫోన్ నెంబర్.
This was the one?
No, further on. Further.
Of this civil liberties movement, there are so many accused, and that was legal a 5-star hotel because accused became grandfathers.
Further.
I was the one come this case has.
Further.
Okay.
Further?
Yeah.
What extent of the court? It is not their values which are on trial, but your values.
Further.
You should use that. That is, shall have the right to life and liberty. And Article 22, which authorizes preventive detention.
That's fine.
You say, so one can understand this because it was a country born in Holocaust, and the Constitutional Assembly wrote in the middle of partition violence. So one understands 22 in its original setting. But then it becomes a habit of the state to govern by preventive detention. And it becomes a legislative habit and judicial habit to say it's okay. And that's what was not intended by the constitution makers. And it fosters what Khanna says, culture of impunity, because it's a very vast power and you can do with it what you like. The courts can only review so much of detention and so on. Although the courts have policed, as it were, detention powers, they don't question them. They cannot because the Constitution authorizes that. It's also a response of state panic. So when political managers are not able to cope, this is a high-handed instrument. Cope with resistance, popular unrest, and so on.
Pathipati Venkateshwara rang up and said, Indira Gandhi has declared a state of emergency and I have just been arrested, so tell Kanakaran as soon as he comes home. And it didn't quite, I mean, I'm very stunned that he was arrested at midnight in state of emergency, but what that meant didn't quite hit me until it kept happening. Every night around midnight, there would be calls, and there would be friends, there would be people who knew who would be who were being arrested, they'd be called saying so and so. And Kanna would just take it very quietly. He'd go, then the next day he would be arguing.
You know, you go to the criminal court, and then I found one inspector saying, here afterwards it is our rule. So I moved the Venkateswarlu's writ petition, writ of habeas corpus, by way of a lunch motion. And it came in the afternoon. I was making my submissions to the court, and I was vehemently contending that there are no grounds for the arrest of Mr. Venkateshwar, because it was at the admission stage, initial stages of the hearing. And if they have grounds, direct the public prosecutor to produce the order and the grounds. Then the public prosecutor foolishly got up and said, the grounds are being typed. The public prosecutor was Obul Palp Chaudhary then, no more. When he said that the grounds are being typed, I said, the court may record the statement of the public prosecutor and release Mr. Venkatesh. Because grounds are not in existence when he was arrested, and it's being typed now. So he is entitled to release. So the judges felt that the public prosecutor may be taken to task for having made this representation. And so to save the public prosecutor, they forfeited the liberty of a citizen.
400 రిపిటిషన్స్ ఆర్డర్ చేశారు సింగిల్ హ్యాండెడ్. ఆ 400 రిపిటిషన్స్లలో డైహార్డ్ నక్సలైట్ దగ్గర నుంచి మొదలుకుంటే లోపల ఉంటే ఎమర్జెన్సీలో ఆర్ఎస్ఎస్ సుబ్బరాయుడు అనే సీనియర్ అడ్వకేటు 14 సంవత్సరాలు ఆర్ఎస్ఎస్ పిల్లవాడు కాగా అన్ని కేసులు ఆయన చేశారు. పైగా ఈ ఫైట్ చేయడం ఎక్కడ అంటే ఒక సూత్రబద్ధమైన దానికి కమిటీ ఉండడం స్పష్టంగా చెప్తున్నారు అడ్వకేట్ జనరల్. ఈయనంతా కంఠశోషాలు ఆర్గ్యూ చేసిన తర్వాత ఈ కోర్టుకు ఇది విచారించే అధికారం లేదు. All the fundamental rights are denied.
So when the emergency says that fundamental rights remain suspended, since the Constitution gave you the fundamental rights, the Constitution can take them back. I mean, it's a very superficial logic. Constitution does not give us rights. Constitution confirms that we have fundamental rights. That is a human rights lawyer's understanding of what rights are all about. If you see them reasoning out on property cases, the reasoning is entirely different. You know, property is inalienable. Property right is an inalienable right, whereas a man's right to personal liberty was considered to be alienable.
During emergency, what was the status of defense committee?
Defense committee became non-functional excepting me. There was only one functioning member. The other functioning member was inside the jail, Venkateshwar, Pathipati Venkateshwar. So some wise guy came to me and said, now that emergency has come, why do you want to continue the committee? Why don't you dissolve it? So I told the member, please don't come if you don't feel like. I will not dissolve the committee, and I'll continue as a one-man defense committee. And that is how I was representing the defense committee in all the writ petitions I appeared.
Some problem,
I asked him, I said, every single person who's been arrested during the emergency has run up here. And I've given you this message saying that, so and so, and you have gone and filed the case. A habeas corpus for that. When you are arrested, who should I approach? Tell me and give me the numbers so that I know who to call as soon as you are arrested. couldn't think of a name.
You talk to me, advocate, you talk to
And
me.
then he gave me the name of one lawyer with whom he had worked very closely professionally and who he had supported enormously in his work, and whatever. That man was making the money, Khanna was doing the work. Srinivas Murthy, Khanna gave me this man and said, see, he doesn't have the guts to come out in the open, so he will not come and file a case for me. But he's very fond of me and I've done so much for him that he will at least move and pay somebody, get some lawyer to appear for me. He will see that whatever is necessary is done for me. So you contact him and tell him. And strangely enough, the next day or the second day after, Khanna came and told me that the day Khanna was walking along the court corridor and Srinivas Murthy just crossed to the other side so that he would not have to wish him. People stopped wishing him, people stopped talking to him. People were afraid of being seen talking to him. And we get information that his name was also on the police list for all the cases that he had done. He was going to be arrested any time. And because of this constant midnight arrests, I remember right through the emergency telling Khanna, I'm just so tired today. I hope they don't come for you tonight again. I hope they wait tomorrow night or whatever.
Yeah, Chandra, that's fine.
Atmosphere.
Thanks. Again, thanks for, I hope again, I think it's useful to see the video in connection with whatever I've said till now. And I think a range of questions come from the video which we played till now, which only is an impetus to you to see the whole video and think of the Constitution with the video as a kind of backdrop, literally, right? The first figure you saw was Upendra Bakshi, and he makes a very important point. And that is the relationship which Suresh will look at between 21 and 22. 21, as we discussed, is the right to life. 22 authorizes the state to preventively detain people. It authorizes preventive detention. So it's actually a provision of the Constitution which allows for preventive detention. So you get the problem. You can't challenge preventive detention because preventive detention is a part of the constitutional provision. So then I hope that logic makes a little more sense. All the stuff is going on and on about. What you could do is to look at whether the detention order was valid as per the statute authorizing detention. That's the limited thing you could do. Again, Bakshi, again, very synoptically, 4-5 lines, he makes a range of very, very important points, which I've been struggling to make for the last, I think, half an hour or so. So you'll get all those points in that quick synoptic reference by Professor Bakshi to the 22, and 22's problem being that it authorizes preventive detention. But that being said, the courts have policed at its fringes the notion of preventive detention, struck down detentions which don't confirm or conform with the statute. That's the Bakshi part of the thing. Then of course you saw Varavara Rao. It's a great pleasure to see him many years ago, of course, in this video, and he's talking about, again, very interestingly, the emergency meant that these two forces were diehard Naxalites and diehard RSS members, and Kanambaran argued for diehard Naxalites, diehard RSS members, young chaps, 14 years old, senior advocates as well. Again, takes you back to a very important point, which is the Constitution uses language. If you're a constitutionalist, right, you come from your way of thinking is with the frame of the Constitution. Khanna's thinking was from the frame of the Constitution. So the idea that if you have been preventively detained, and if your right to life has been, personal liberty has been violated, you're entitled to a legal defense. You're entitled to be released, regardless of what your ideology may be. So human rights thinking, in that sense, comes from the ideology of thinking of human rights, not necessarily from the ideology of the either the far left or the far right, as the case may be. So you think from the language of the lens of human rights. And of course, the last point, which comes to the conversation between Khanna and Vasant Kanambaran, is what we discussed in the last class. Right? Is the entire question of fear and the entire question of what the emergency does as far as people are concerned and ordinary human relationships, right? How it perverts, subverts the idea of, what it means to form a friendship with another human being, what it means to stand in solidarity with another human being, all of which gets subverted or perverted through this process called the emergency, right? So that's as far as the clip is concerned. If anybody has any thoughts, we can talk a little bit about it. If Suresh or Sala, you want to comment on that in any points?
No, just to discussed at the last hearing that, at the last discussion class that we had, how, the state can easily subvert the constitution by instilling this fear. And I think as citizens, the main thing that we need to guard against is to fear itself. I think we need to fight that fear, and all that is holding us back very often is fear. And if we are able to fight that fear, the real enemy is only fear, actually. So once we overcome that fear, then I think handling the rest of it would fall in place, because then the road is very clear. If we set aside the fear, we know then what is the right thing to do to safeguard the rights. And I think what the film also what we are trying to impress is how, as citizens, if we are not proactive in safeguarding our rights, the possibility of losing them altogether is so real. So the film has shown you that even the top leaders, all the opposition leaders, were put behind bars. And in today's news, probably you can see in what is happening, the way the elections in New Delhi, what is happening to AAP. They were wanting to release some propaganda video which has been banned. I think that is the news today. So how, we are still hanging on a very thin thread. And unless we as citizens are very proactive in trying to assert those rights, and by fearing fear and not fearing the state or the police action, I think that is what this movie tells you. And how it is so easy for all of us to get so dehumanized that we forget the preamble. How Mr. Kanabiran and Vasant were talking about how suddenly they become isolated. Why? For doing the right thing, for standing up for rights, for asserting what the Constitution has guaranteed us. How suddenly everybody, all the friends and that too lawyers, are shunning their very company. So once that fear goes, it's so much easier for us to do the right thing and say, what is wrong? Whatever we are doing is as per the Constitution. I think that is the kind of constitutional thinking and courage that all of us should pick up. Yes, Arvind, you can continue.
Yeah. Thanks.
Actually, it is not only in these large issues of, police coming to your doorstep, but even in our day-to-day lives, I think very often it is fear which holds us back from asking the right questions or from doing the right things. So I think that is the first fundamental thing that all of us have to deal with internally at a very personal level, and say, for doing the right thing, why do we fear? It is across the, bureaucrats. We are finding scam after scam after scam, which means bureaucrats don't hesitate to do the wrong things. But when you ask them to take action against somebody who is a wrongdoer, then they have so many apprehensions. What if so-and-so feels bad? What if some minister gets offended? These are all irrelevant questions. So to do the right thing, we are afraid. But to do the wrong thing, we don't think twice. So I think this is the culture that we have got into, which is the culture of impunity, which, I think Bakshi talks about. We have got habituated to it. That, we are comfortable with doing the wrong thing, but we are fearful of doing the right thing. So I think all of us need to introspect on this, because ultimately understanding the Constitution is all about, I think, re-evaluating where all of us stand in our own personal lives and in our personal conduct, the way we all deal with both personal and public issues.
And
Thanks.
professional as well.
Yes, very true. Professional as well. Yes.
Thanks, Sada, for reminding us that the only thing you have to fear is fear itself. And that's really, it goes back to Roosevelt, who made that point in a speech. saying the only thing you have to fear is fear itself. So I think it's a very important concept to take away. Suresh, if you'd like to come in, you're on mute.
I would like to add here that the issue of constitutional morality that Arvind was talking about is not limited to how you treat other human beings. It is also encompasses within itself two things. One is a consciousness of human rights, okay, and consciousness of the need that it is a duty of all citizens to rise up to protect it. So constitutional morality is not just in the realm of social relations. It is also in the fact that these rights come to us because we are born here in this country, or we are here in India. But these rights it's not sufficient for the rights just to be on the paper. It is up to us to defend it if it is violated. Now, that's a very, very important element to look into it, because this was debated in the Constituent Assembly. The whole issue of Article 21, the right to life, was debated at great length. They compared eventually what occurred in Article 21, what has been written as a text. They compared it with the text in USA. They compared it with the text in other countries. And many of the people who participated in the discussions also talked about the fact of how they have suffered with the British, and how in a free India, what is it that they did not want the law to do. They also talked about how it is important to assert the rights of citizens vis-a-vis a brute state. Arising from these debates is the text of Article 21, which seems to be just 2 lines. But within those 2 lines encompass a whole lot of realities, as we shall now see once Arvind finishes the next part of his lecture.
Yeah, thanks. So we'll take from here, and so we've had these 9 High Court judgments which have struck down detention of the detainee on ground that the law is not complied with. And now the matter goes before the Supreme Court. And of course, you can imagine that, again, it's possible to think that somewhere in the south, things might be a little more easier compared to Delhi, which is the closest to the power of the central government. You see that in particular in the emergency during the demolition. The worst demolitions happen in Delhi. Detentions, of course, happen throughout the length and breadth of the country. But the sense of fear, I think, would be higher in terms of the closer you are to the center of power, which is Indira Gandhi and Sanjay Gandhi, the higher the sense of fear. And Supreme Court, of course, is in Delhi compared to the various high courts. And possibly, I don't know, possibly the judges have lesser ability to be free from fear than the judges in the high courts. And we see that in terms of, again, I want to take you through a bit of what Justice Khanna, his autobiography called Neither Roses Nor Thorns, right? And he reflects back upon the emergency judgment. I'll just open it out for you, and somebody can maybe just read that. Is it visible, the Mr. Nirinde, Attorney General?
Yes, Arvind.
Okay. So this is from Justice Khanna's autobiography. Somebody just start reading from here, please. Well, just before that, Nirinde was, of course, the Attorney General. In the arguments, he represented the Union of India, and the opposition, in terms of, the people who were detained, were represented by a range of figures, right from Shanti Bhushan and Anil Devan to Rani Palkiwala to others. Yeah. So just begin with what Nirinde had to say. Yeah. Please read it. Yeah. Somebody please.
Somebody read it.
Okay, I'll read.
Yeah.
Okay, Mr. Nirinde, Attorney General, who argued on behalf of the state, contended, as had been done before the High Courts, that as the right to move the court for enforcement of Article 21 has been suspended, writ petitions were not maintainable. I sought some clarifications about certain aspects, to which Nirende gave replies. It was, however, found by me that some of my colleagues who in the past used to be very vocal about human rights and civil liberties were sitting tongue-tied. Their silence seemed rather ominous. In the course of discussion, I put it to Mr. Nirende that Article 21 related not merely to personal liberty, but also to life. In view of his submissions, would there be any remedy if a police officer, because of personal enmity, killed another man? The answer of Mr. Dey was unequivocal. Consistently with my argument, he said there would be no judicial remedy in such a case as long as the emergency lasts. And he added, it may shock your conscience, it shocks mine, but consistently with my submissions, no proceedings can be taken in a court of law on that score. The above answer put the matters in plain light and left nothing in doubt so far as the position of the state was concerned.
Yeah, just on Justice Khanna's autobiography, any guesses anybody can say? However, found by me that some of my colleagues who in the past used to be very vocal about human rights and civil liberties sitting tongue-tied. Who is he referring to? Okay, I'll put it this way. It's 5 judges who sat on the EDM Jabalpur case. One, of course, is Justice Khanna delivered the minority opinion. Then there's the Chief Justice Ray, Justice Beg, Justice Bhagwati, and Justice Chandrachud the Senior. These were the five judges, right? So who is he referring to? Who do you think he's referring to?
That's a quiz very difficult for them to
talk on.
To talk on. Can anybody take a guess?
I think supersession was done by Mrs. Gandhi, and A.N. Ray was made the Chief Justice after that.
Okay, another try. Who are very vocal about human rights and civil liberties. That's a catchphrase.
And
Justice Bhagwati. It was Justice Bhagwati, I think.
Yes. Justice Bhagwati and Justice Chandrachud, right?
And Chandrachud. The present, the one who recently retired, his father.
His father, yeah. So that's one point to note over here. Second, see, there's a very important discussion here, right? Look at the question which Justice Khanna asked, right? Article 21 relates to personal liberty, but also to life, right? And so, because you take away your ability to approach the courts, if somebody kills, a police officer kills somebody out of personal enmity, what happens? And Nirende's answer is clear. He says, too bad. Nothing can be done about it. Because you don't have the right to move your court for enforcement of your right to life during the time the emergency is in force. And again, that's a very interesting one line, right? The above answer put the matter in plain light and left nothing in doubt as far as the position of the state was concerned. So everybody knows this is the state's position. State's position is we will do what we want. Nobody can ask us a single question if we kill somebody on the street. No questions asked. You can't ask the question, is it in conformity with any law? Because we can do exactly what we want, because you cannot move the court for enforcement of your fundamental rights. And that's the position taken by the state. Maybe maybe just one more paragraph, please.
The point to be noted here is that the Attorney General is the highest law officer of the government. Okay, there are 2 officers who are mentioned in the Constitution itself. One is Attorney General, the other one is the Solicitor General. But the Attorney General is the highest. So the highest law officer representing the government of India says, I am shocked, but that's the law. And if a policeman decides to kill somebody, there is no remedy at all. Okay, this is a stand taken by the government of India in 1975, 75, 76. Okay, go ahead.
Yeah. Somebody please, the next paragraph. Go on, please.
Soon after the conclusion of arguments, which covered a period of about 6 months.
A little closer to the mic, please.
Am I audible now?
It's very, very light.
Nandakumar, are you talking to us or are you talking to somebody else?
Go ahead.
Soon after the conclusion of arguments, which covered a period of about 6 or 7 weeks, I started dictating the judgment. From the way my other colleagues on the bench made remarks or kept silent, I became convinced that the way I was thinking, I would be the solitary judge to decide against the state, and that my judgment in the very nature of things would have to be a dissenting judgment.
Go on, go on.
Article 21, in my opinion, was
No,
not
no,
the
no. I think even the white portion, so far as I was concerned.
So far as I was concerned, my approach was that the suspension of the right to enforce Article 21 could not have greater effect than the repeal of Article 21. Supposing Article 21 was not there in the Constitution, no state and no policeman, even in absence of that article, could deprive a person of his life or personal liberty without the authority of law. If they did so, they would be guilty of culpable homicide or illegal confinement. Article 21, in my opinion, was not the sole repository of the right to life and personal liberty. Those rights had existed even prior to the framing of the Constitution. To hold that because of the suspension of the right to move the court for enforcement of Article 21, any policeman could malafide, kill, or keep in confinement any man, and there would be no remedy against such killing or detention, was tantamount to declaring that there was no longer any rule of law. When the acceptance of the contention led to such consequences, the court should, I felt, incline itself to the other view that despite such suspension of the right, the judicial remedy was not barred.
Yeah, maybe just read the next paragraph and we'll stop with that. Yeah.
Someone else read it.
I'll go. It was, however, plain to me that my colleagues were going to accept the contention of the Attorney General. It was also plain that if I gave the judgment as I was contemplating, I would have to lose the office of Chief Justice of India, as the then incumbent of office was due to retire in some months' time, and I was next to him in seniority. I could not entertain any illusion in this respect, as there had already been a precedent in 1973, when three senior judges had been superseded for the office of Chief Justice when they gave their judgment against the state.
Thanks. So I think these two paragraphs, again, are very, very useful in also understanding this psychological dimension, right? The question of courage and fear, which we're talking about. You can see that the other colleagues, the way the remarks they make or the way they keep silent, Justice Khanna knew that he would be the solitary judge to decide against the state. And the judgment would have to be dissenting judgment. The other thing he also knew is it's not just that you're going against the state, you're losing any kind of a personal benefit. He knows that Indira Gandhi is a particularly vengeful character, and history has proven that if you go against her, nothing good will happen to you in terms of benefits. Previously, in the Keshavananda Bharati case, the three judges who delivered a judgment against for the basic structure doctrine were all superseded by the then Indira Gandhi regime. So he said, I knew that I will not be Chief Justice if I give this particular judgment. So again, you see the consequences, which is very conscious of and the fact that he knows that he's going to be a solitary voice as far as this particular judgment is concerned. Okay, this is the background. Now let's get to the judgment itself, which is what we want to look at. And we look at some of what Chandrachud as well as Bhagwati said, and then we'll look at the Khanna judgment. This is Chandrachud's conclusion, right? Just read it.
May I?
Please do.
Council after council expressed the fear that during the emergency, the executive may whip and strip and starve the detenue, and if this be our judgment, even shoot him down. Such misdeeds have not tarnished the record of free India, and I have a bright, diamond heart hope that such things will never come to pass.
Yeah. So the arguments of the entire council defending the detenue is dismissed, right? With the language of the hope. What is the hope? The hope is diamond bright and diamond hard, that such things will never come to pass as far as India is concerned. Let's see what Justice Bhagwati has to say. Yeah. Just the highlighted part, please.
I'll read it.
Yes, please.
The maxim salus populi supremo lex esto, that is, public safety is the highest law of all, must prevail in times of crisis, and the people must submit to temporary abdication of their constitutional liberties in order to enable the government to combat the crisis situation which might otherwise destroy the continued existence of the nation.
Okay. So you got Justice Bhagwati's opinion. Now look at Justice Beg again, one line from Justice Beg. Yeah. Please go continue.
It seems to me that courts can safely act on the presumption that powers of preventive detention are not being abused. The theory that preventive detention serves a psychotherapeutic purpose may not be correct, but the constitutional duty of every government faced with threats of widespread disorder and chaos to meet it with appropriate steps cannot be denied. And if one can refer to a member of common knowledge appearing from newspaper reports, a number of detainees arrested last year have already been released. This shows that the whole situation is periodically reviewed. Furthermore, we understand that the care and concern bestowed by the state authorities upon the welfare of detainees who are well housed, well fed, and well treated is almost maternal. Even parents have to take appropriate preventive action against these children who may threaten to burn down the house they live in.
Yeah. So great. We saw a sense of, Justice Chandrachud's diamond bright, diamond hard hope, such things will not happen in India. Justice Beg's idea that the way the detainees are being treated, right, is almost maternal, right? The care given by the state authorities over the detenue who are well housed, well fed, and well treated, almost maternal, right? So you get a sense of the almost, completely different world in which the majority is living. And finally, they conclude. What do they finally conclude? Which is the key part as far as we are concerned, is on 232. So please continue reading.
The presidential order dated June 27, 1975 bars any investigation or inquiry into the question whether the order of detention is vitiated by malafides, factual or legal, or whether it is based on extraneous considerations, or whether the detaining authority had reached his subjective satisfaction validly on proper and relevant material.
Yeah, you just relate this again, what do you say, densely packed language of legalese to the Justice Khanna's question, which he asked Narendra, right? That's the point. You think the presidential order bars any investigation or inquiry into the question whether the order of detention is vitiated by any mala fides, factual or legal, or whether it is based on extraneous consideration, or whether detaining authority reaches the subjective satisfaction validly or properly on relevant material. So basically, you're saying the detention order is there. That's all that matters. That's all that matters. We don't need to ask any further question. Story over. That's the conclusion as far as the majority is concerned. Right? And I'm not going to read the next part of it, but Justice, there's a Sirwai's opinion. Again, Sirwai is a very important legal scholar. His opinion is this opinion of the court coming at a point of darkness in Indian history, made the darkness complete. It extinguished the last possible hope that you had that there'd be any redress, and the starkness of it was there in the Justice Khanna question. If a police officer shoots you down on the street because there's a personal enmity for you against you, what can be done? The answer of the Union of India is nothing, and the majority buys that line of an argument. Buys it for reasons of fear. Buys it because the state is saying it. We have no other way to go. Buys it for whatever reasons, but they buy that particular logic and that particular reason. Right? And you have this majority, which is just, again, the majority opinion today, right? If you go to the Puttaswamy judgment, the three lowest points in the history of the Indian Supreme Court is seen as one of them is ADM double P. Right? It's seen as the lowest point. And it is, because you say the right to life or personal liberty can be taken away by the state arbitrarily. What is left? There's nothing left as far as the Constitution is concerned, right? So this is a very important judgment to understand what the worst which can happen. But of course, there's the worst which can happen, and then you have the Justice Khanna dissenting opinion, which I think again is useful to go through a little bit. We'll just go through that just very, very brief, not very, very briefly, as much as we can.
I think as Arvind is getting to Justice Khanna's opinion, I think go back to the language of Article 21, which is no person shall be denied right to life or liberty except by procedure established by law. And during emergency, it is a procedure established by law. So there is a MISA Act was there, the Maintenance of Internal Security Act. So which is a procedure established by law. And hence that's the end of the matter. So the state can take away your fundamental right to life and liberty as long as there is a law which is enacted, there is a statute, and they arrest you on the basis of that statute because it is a procedure established by law. So what we need to ponder is that what the Constitution, those words mean? So keep that in mind and now read, we can proceed.
Yeah. So let's look at what the core conclusion as far as Justice Khanna is concerned. Let's read paragraph 200, please. Have we done too much of reading for the day, guys?
Are you all tired?
I'll read. The cases before us raise questions of utmost importance and gravity, questions which impinge not only upon the scope of the different constitutional provisions, but have impact also upon the basic values affecting life, liberty, and the rule of law. More is at stake in these cases than the liberty of a few individuals or the correct construction of the wording of an order. What is at stake is the rule of law. If it could be the boast of a great English judge, Lord Mansfield, in the case of James Somerset, that the air of England is too pure for a slave to breathe, cannot we also say with justifiable pride that this sacred land shall not suffer eclipse of the rule of law, and that the Constitution and the laws of India do not permit life and liberty to be at the mercy of absolute power of the executive, a power against which there can be no redress in courts of law, even if it chooses to act contrary to law or in an arbitrary and capricious manner. The question is not whether there can be curtailment of personal liberty when there is threat to the security of the state. I have no doubt that there can be such curtailment, even on an extensive scale, in the face of such threat. The question is whether the law speaking through the authority of the courts shall be absolutely silenced and rendered mute because of such threat.
See, here is a very important concept which is being put forward, which is the idea of the the rule of law. See, the argument, right? I mean, it's a very important argument. The argument is not that you can't declare an emergency. You can. The state has the power to proclaim an emergency. But the question is, when the emergency is proclaimed, will the laws speaking to the authority of the courts be absolutely silenced and rendered mute? That's the question, right? So what happens to law during the emergency? That's the question which is being raised as far as Justice Khanna's opinion is concerned. That's one part of it. The second part of it, of course, is that the Constitution of India and the laws of India do not permit life and liberty to be at the mercy of absolute power of the executive. Again, you go back to the question which he asks, Nirinde, right? Can you shoot somebody down in the streets? And if the answer is yes, then the argument of Justice Khanna is you may say yes, but you work under the Constitution. The Constitution doesn't recognize your right to shoot anybody down in the streets. It does not recognize it, right? And the rule of law does not allow for you to exercise power that, again, in the language of arbitrary and capricious manner, right? So the argument is not that you can't curtail personal liberty. You can curtail personal liberty, but when you curtail personal liberty, you must act in a manner which is not arbitrary or capricious, and not in a sense of a question of using of absolute power. Then we just look at one more paragraph. Okay, this I'll just read this myself. Even if one of the many grounds on which a detention order is based is not germane or legally not tenable, the detention order would be quashed because it is difficult to predicate that the detaining authority would have come to the requisite satisfaction even in the absence of that ground. It is plainly not possible to estimate as to how far the irrelevant or untenable ground operated on the mind of the appropriate authority and contributed to the creation of the satisfaction on the basis of which the detention order was made. To say that the other ground, which still remains quite sufficient to sustain the order, would be to substitute an objective judicial test for the subjective decision of the executive authority, which is against the legislative policy underlying the statute. There's again a lot of legalese over here, but the simple point I'm making is that again you have to get back to the question of law itself. Right? Your detention order, end of the day, has to be based on a ground. If the ground is not there, you go back to the Kanavaran statement, right? He says he says the record the submission of the government, who says the ground is being typed. So the ground is very important. The ground has to be there. The ground has to indicate that on the basis of which the authority is satisfied that the person should be detained. Right? Again, you get back to the notion of, again, you want to distinguish it, right? Rule of law and the Constitution can be two concepts. They're related, but they can also be seen as two separate concepts. Because what the point which one is making here is the rule of law is something which exists even with the Constitution is not there. And that's the point which Justice Khanna is making. If you're a rule of law society, you will continue to be a rule of law society even if the Constitution is not there. Right? And that's the question of, there's a law, is a conformity to the law. That's what you test. Again, there's a very important line in the judgment where Justice Khanna makes the point that the history of civil liberties is a history of the insistence upon procedure. Right? Again, a very important point, right? When we talk in grand terms of human rights, end of the day, the grand terms of human rights can come down to the question of the insistence on procedure. Very important and very important way in which we can think of taking forward the entire question of constitutional rights. And maybe the last point I want to quote from the judgment, and then we'll end with that. Last point Justice Khanna I'm going to quote now would be this. This is the last paragraph, right? Absolutely last paragraph of the Khanna dissent. Just please read this last paragraph.
A dissent in a court of last.
Read the whole thing. Read the whole thing.
Before I part with the case, I may observe that the consciousness that the view expressed by me is at variance with that of the majority of my learned brethren has not stood in the way of my expressing the same. I am aware of the desirability of unanimity if possible. Unanimity obtained without sacrifice of conviction commends the decision to public confidence. Unanimity which is merely formal and which is recorded at the expense of strong conflicting views is not desirable in a court of law last resort. As observed by Chief Justice Hughes Prophets, which honored by Alan Earth, 1974 edition, page 36, judges are not there simply to decide cases, but to decide them as they think they should be decided, and while it may be regrettable that they cannot always agree, it is better that their independence should be maintained and recognized than that unanimity should be secured through its sacrifice. A dissent in a court of last resort, to use its words, is an appeal to the brooding spirit of the law, to the intelligence of a future day, when a later decision may possibly correct the error into which the dissenting judge believes the court to have been.
Yeah. So you got the fact that it's a minority judgment, and it's an appeal to the what Justice Khanna calls the brooding spirit of the law, and to the intelligence of a future day. And the judgment itself, again going back to the emergency time, there's censorship. The judgment is not reported at all, or broadly, or widely in the circles. They ensure that the minority judgment is not reported, so people don't know that there's a dissent of that kind of a consequence. Of course, lawyers who are there know, but it's not reported by the media. But it gets picked up. Interestingly, that dissent gets picked up in not in the Indian paper, right? Because Indian papers can't report it, but by the New York Times. And the New York Times pens a very powerful editorial in which they say that, I'm just quoting this from memory, they say that if India ever finds its way back to freedom, then a statue will be erected to the memory of Justice Khanna. Right? So the idea that dissent is an appeal to the future. Right? So it's a very, very important, the fact that there was a dissent. And it kept that spirit, right, of hope alive. That there are people who think differently from the mainstream, and the people who think in accordance with the Constitution, in accordance with the values and the spirit of the Constitution. The Khanna dissent is picked up, of course, by the New York Times, and then in his autobiography talks about how different people read it and send him clippings, right? Clippings of the New York Times article. So you see how it circulates in a different way within that society at that moment in time. Of course, then he's superseded for the Chief Justiceship, etc. Right? So that's the story of a judge who had the courage of his conviction and stood his ground, regardless of what it meant to go against the thinking of the state as it were. And it just one last point one will make on how sometimes dissenting judgments are very important and very useful, and courage is often respected or valued, even in of course in places where it's not there. Right today, if you go to the court hall number 2, which is where Justice Khanna sat, court hall number 1 is where the Chief Justice sits, court hall number 2 is where the second senior most judge sits, and the only court hall in the Supreme Court which has a portrait of a judge is court hall number 2, and there's a portrait of Justice Khanna. There's no statue to him. There's a portrait in the Supreme Court. Why that is important again is what I gather is that when Justice Khanna Jr. was in court hall number 2, the lawyers making arguments would appeal to the spirit of Justice Khanna, in hoping that the current Chief Justice, then the second senior judge, would also take forward some part of that particular spirit. Right? And so there's a way in which all this becomes not just a conversation about the past, it can also become a conversation about the future. Not just an archival interest, it's an interest in the future. We're not interested in the past for the past's sake. We're interested in the past, as though the past can shape the future. So there's an appeal to, again, Justice Khanna might be one of the most important judges, though he's not Chief Justice, in the history of the Indian Supreme Court. You'll see that in a range of spaces, where the judicial trainings, judges often end their colloquium by stating to their junior judges, may you go on to become judges like Justice Khanna. Right? May you go on to show courage like Justice Khanna. So there's a way in which he stands for courage, he stands for integrity, and stands for that quality of of speaking truth, regardless of what power may think, regardless of the personal consequences you may have to suffer. Right? So again, the reason I spent some time on the minority judgment is to make the point that again, this goes back to what something which Hannah Arendt wrote in the book called Men in Dark Times. Very important book where she makes the point that sometimes even in the darkest of times, right, where you derive some sense of hope is from the flickering light which some people's lives cast upon the future. Right? So there's a way in which people's lives can be an inspiration. And in that sense, it's very important to go back to Justice Khanna's time and Justice Khanna's work. Right? And this is in terms of how he kept alive what Article 21 said. Post-emergency, we've seen the growth, the efflorescence of Article 21, which I think Suresh will briefly touch on now, unless there's some questions on this part.
Arvind, let's hear a few voices.
Yeah, sure.
Would any of you like to share your views, comments? What did you understand? What did you not understand before we get into the second part? Yeah.
What I have understood, even people sitting at the highest court of justice, even they feel fear not coming out and not taking a decision as per the law, not listening to their conscience.
All right. Thanks, Mahendra Kumarji. Anybody else? Ujjwal, Sendil, Mohan. Mohan.
To me, it sounded like at least Justice Khanna's thing was very inspirational. And even Kannabran's also, like how all these people have been lone warriors in these times, and which is very similar to what's happening in the current times also. Like, I don't know if it's comparable or something. Like when we look at what's happening to all the Bhima Koregaon people, or even the Umar Khalid, like what do we actually do? And when I keep hearing to China and others, like you can't deny that, just rely on the quotes, but we have to do a larger than that. And in doing larger than that, like, is there some sort of a strategy we should do, or is it like going onto the street and then doing something? And it could sound very rash, and it's not just the fear, but also uh, it's quite easy to become a prey and get attacked also. And so in that sense, like, what is the strategy which we should do? And it's not just, I don't know if it's the fear, but is it a good idea? Like, what is that we should do, which is difficult to digest, and still it is a sense of helplessness plus a sense of wanting to do really something tangible. Yeah.
Thanks, Sendil. I think you are echoing a lot of people's inner feelings when it comes down. But that is the test of the Constitution. The test of the Constitution is not something that you read in a classroom or you hear in a lecture, or you hear somebody saying article this, article that. The test is in the reality, because the Constitution is precisely created to help us deal with reality of day-to-day life, reality of dealing with the state, dealing with the police, dealing with people in power. And yes, Sendil, that is what Khanna has written in his book also. The reality that you have to face the consequences of standing by your conscience. And he paid the price. He was not elevated. He resigned.
But anyway, see, going back to what Sendil said, it's not like we have any blueprint or any answers for that question. But I think what is important at this point is for us also to, I think what at least this bringing home the Constitution, that today the discussions that we are having, it is not so much as just to give you a lesson in the Constitution and tell you this article is that and this is, but to even engage in a dialogue, engage in critical thinking, in a critical analysis to understand our reality. So the first is an understanding of our reality, to see it for what it is and not get caught up in the lot of noise that, you get in the WhatsApp groups and a lot of misinformation that is, and deliberate propaganda that is being thrown at us. How do we as citizens develop critical thinking so that we are able to ascertain for ourselves, using the constitutional principles and the history of our country as a benchmark, to understand right from wrong and to stand up from it? So that is the first part. First is to equip ourselves to become aware. And I think to a large extent, being aware and conscious of our rights, and followed by the fact that we are not alone, that there is a group, like even in, like Mr. Kannabiran was talking, while yes, they are seen as lone warriors, the fact remains that while these are the stories that we know, but there are a lot of unknown stories, unknown heroes and heroines who fought who opposed the emergency. Young students. The student movement was very active. So yes, it has, like, a lot of people have come forward. There are so many unsung heroes who have. So I think we don't have any answers, but the fact is, like, when a situation is warranted, when we are called upon to do something and let our conscience speak, I think fear should not hold us back, or ignorance should not hold us back. So I think first is handling our ignorance, equipping ourselves with the power of knowledge and the power of critical thinking, and thereafter find the spaces to engage. We don't need to wait for that extreme situation like Bhima Koregaon, Umar Khalid. Yes, those are definitely issues that, a lot is happening. It's not protests are happening. So much is being written about. But you will see that there was a point in time that even, putting a Facebook post, people were worried, because you are worried that the police will come to your house. I think today we have overcome that. There are more voices being heard. So that is the first step, I think, to deal with our fear and to come forward. So I don't know if that answers any of the questions. And if it comes to it, yes, we have to go on to the street. But nobody is saying that, you be foolish about it. We have to be strategic. We have to be tactical. But we should be engaged in what is happening.
Does anybody have any other view? Otherwise, we thought we'll run through broadly how Article 21 has been shaped from 1950 till date.
Sandeep just makes a small point. I'm still processing this, but it's fear invoking to realize how freedom will remain constant struggle and fight with the power. And he apologies he couldn't come on mute to share, but yeah, he wrote that in chat.
Okay.
So, now let's get back. The idea of these sessions are, one is, of course, to give you critical thinking, but also to give you the inputs about the law, the content. So as I've always been telling, we have been trying to balance the two, because one without the other may not be very effective. But too much of only one thing is also not good. So, so we need to balance both.
So when you're talking about right to life and liberty, there are 3 articles we need to keep in mind. Article 20, Article 21, and Article 22. They are a package. And again, it will be very interesting for you all to go back to Constituent Assembly debate to see how these 3 articles were shaped at the time of the constitution making. Very soon, we are going to be celebrating 75th Republic Day. Then you will recall the sacrifices made and the debates and the discussion and the fights which eventually end up with these 3 articles. So Article 20, for example, point number 3 and 4, protection against double jeopardy and privilege against self-determination. That's Article 20. And first,
21.
Protection against ex post facto law. So this is laws which would sort of criminalize any action. So that is Article 20.
See, Article 20, I think we have subdivided the clauses for easier understanding. So right to life and personal liberty, which we have read since the last 1 hour, is Article 21. Now, Article 20 itself, subclause 1, is essentially a protection against ex post facto law. Now, what is the meaning of ex post facto law? Now, post facto, that is after the fact. Supposing, okay, let us say that having Zoom meetings like this is hereafter illegal. So that such a law is pronounced tomorrow. Tomorrow, the Tamil Nadu government or the government of India makes a law that citizens having Zoom meetings and discussing the constitution is a offense. Apart from violating many other laws that we have discussed, but I'm just looking at it from the ex post facto principle. Now, can all of us who are participating in the Zoom meeting today be charge sheeted under a law which has come into existence after we have done the
the incident
has taken place? Because today there is no such law. Today having this Zoom meeting is perfectly legal, but tomorrow they pronounce it illegal. So can the government make any law? Can a state make a law which makes an act criminal or an offense ex post facto, that is after the law? So Article 20 clause 1 prevents such a enactment, and it says you cannot criminalize any act after the act has been committed. So a citizen has a right to know what is wrong and what is right, so that accordingly they will calibrate their actions. So today none of us know that tomorrow there is going to be a law which is going to ban Zoom meetings. So today we are perfectly fine. So that is what ex post facto is all about. Then subclause 2 of Article 20 is protection against double jeopardy. So double jeopardy, we don't want to go too much into details, but very simply, you cannot be tried for the same offense twice. So for instance, today you are charge sheeted for theft, for stealing a computer from a place, and there's a trial after which you are acquitted. Then suddenly tomorrow somebody else comes and says, no, I have come across some more evidence. We want to try you once again for the very same offense of which you have already been acquitted by a court. So that cannot be done. So it's a protection against double jeopardy, to be tried for the same offense twice. That is what is the protection against double jeopardy. Then subclause 3 of Article 20 is a right against self-incrimination. It's not determination, it is incrimination. That's a typographical error. So self-incrimination, that is the right to silence, essentially. That is, if tomorrow somebody, if the police files an FIR against you and makes you an accused, now the law protects you. There is no, law which tells you that you have to go and tell the police all that you know or don't know about a particular act of which you are accused of. Now, you might have been seeing recently in the news how in cases of, I think even Mr. P. Chidambaram, I think Rahul Gandhi, all the top, both activists as well as opposition party leaders, time and again you have the Enforcement Directorate calling you for investigation, asking you to appear before the investigation officer, and then they are coming back to the court and saying, no, we are not getting enough information. This person is not cooperating with the investigation. They are not answering our questions. Now, all this actually, is against the protection given under subclause 3 of Article 20, because the right against self-incrimination is a right which is given by the Constitution, which means every accused has a right to remain silent. It is the job of the prosecution or of the state to find the evidence to convict you of any offense. You are not expected to give the evidence to help them to convict you. So that is the right which is given by the Constitution. And so today, this kind of frequently calling the accused people to the police and telling that they are not cooperating, there is no duty cast upon the accused to cooperate. As a witness, yes. As an ordinary citizen, yes. Under the Criminal Procedure Code, if any policeman asks you any legitimate questions, we as citizens have a duty to inform the police about whatever we know. That is there. But the moment you become an accused, if you are accused of a crime, you have a right to remain silent. So now there have been frequent attempts to water down this protection, very valuable protection that the Constitution gives you. Then we are going to Article 22. Now, Article 22 is about the protection in case of arrest. Now, because you're talking of Article 21, which is your right to personal life and liberty, and the moment a person is arrested, what happens? First, your liberty is definitely curtailed the moment you are arrested. So that is why the Constitution itself brings in the protection saying that if you are arrested within 24 hours, you need to be produced before a magistrate, that is before a judicial officer, who will then assess whether the arrest is warranted, and then only if the magistrate orders that you can be detained, that detention can be continued beyond 24 hours. So that is a constitutional protection which is guaranteed. And what Article 22 also guarantees is a right to having legal aid. That is, you have a right to consult your lawyer. So these are two very important constitutional rights which are guaranteed to you. Then Article 22 to 4 to subclauses 4 to 7 is all about preventive detention, which is what we have been discussing so far. The contradiction between Article 21, which guarantees right to life and personal liberty, and Article 22, which gives the Constitution itself gives the state the authority to make a law to hold a person in detention, that is to arrest a person, not because you have committed a crime, not because a court of law has found you guilty of an offense after all the evidence has been produced before the court, after a full-fledged trial, but as a preventive measure. That is, the state or the police can, if they have an apprehension that you are likely to commit an offense, then in order to prevent you from committing that offense, they can detain you in custody. So this preventive detention has been authorized by the Constitution itself, which is what you have seen in the film on Mr. Kannabiran, that advocate film, which Mr. Upendra Bakshi, who's a very great jurist, who talks about this contradiction between 21 and 22, which even in the Constituent Assembly debates, there is extensive debate. A lot of people opposed the introduction of 22 in the, and of course, the rest of the clauses gives you the procedure about having an advisory committee, etc. We don't want to trouble you with all that, as long as you understand this bare bones of these articles.
See, the privilege against self-incrimination is very important now. For example, when they come and arrest you and take your gadgets, and they tell you to give passwords, are you required to give or not? Does the right of silence include not giving details about your passwords? Okay. Now, this is a very burning issue now. There's still not very great clarity about it. People like Arvind, I, myself, Saila, and others in the PUCL have been arguing that no, yes, right to silence includes right not to give passwords. It's for the police to get the passwords. A small sliver of hope is from a ruling from the Delhi High Court recently, which said that there is no compulsion on the person arrested to disclose the passwords. It's for the police to find it. Just to tell you that all these points are not points only for some political activist. Many of these things are important even for us in our day-to-day life, maybe in our work, in a fight with a neighbor, something that happens in our neighborhood, or in terms of when we have to tackle with people in authority. Okay, so these are all day-to-day issues that we need to know. Yes, Sayantan?
One small question. So preventive detention, does it apply for all sorts of crimes or particular crimes which sort of threaten public order or of that magnitude which we discussed last class?
Basically, it should be for public order, and there are special laws that have been brought about because law and order is something which is at a lower level, as we discussed last time.
So the Constitution authorizes the state to make laws for preventive detention. And so now over a period, for instance, in Tamil Nadu, we have what is called the Gundas Act.
It's there in
For
every
short,
state.
it's there in most states. Then you have
National Security Act.
Then you also have for the prevention of smuggling,
Coffee Posa
Coffee
Act.
Posa you have. So now there are a lot of preventive detention laws on various things.
Okay, we will not get into preventive detention now, Sayantan, because it's a little more complicated than the regular law. We're short of time, so let's run through the provisions. I hope you all have a clear idea. Article 20, 21, and 22 are the articles relating to personal life, liberty, vis-a-vis the power of the state to arrest you. Okay, so we have done this. So no person shall be deprived. That's Article 21, except according to, we have underlined this. So when you're reading any law, you need to know which are the provisions that you need to keep note of. Okay, now we go back to the earliest case which was filed relating to 20, 21, and 22 was of a very major political Communist Party leader called A.K. Gopalan.
I think Arvind had also mentioned to you, if you recall the earlier lectures, about how he actually took out a procession within the prison. He was in detention when we got independence, and he took the national flag and went around, and he was detained for it, and the detention was extended. So anyway, A.K. Gopalan is a very celebrated case where in the first constitutional, where they invoked Article 21 to challenge the preventive detention the order. And this was precisely the argument which was put forth by A.K. Gopalan, saying that Article 21 says, yes, that the life and liberty can be removed, can be deprived by procedure established by law. So what A.K. Gopalan said is, it's not enough that, there is a law which provides for, depriving my personal liberty. That law should also be a fair law. It should be a reasonable law. So the words procedure established by law contemplates that it should be a reasonable and a fair procedure. And you cannot simply pass a preventive detention order, because you also have to keep in mind not just Article 22, but take into consideration Article 19 and 21, because everything flows one into the other, and you cannot keep them into watertight compartments, and hence the preventive detention law is bad. The order is bad, and all his contentions were rejected by the Supreme Court in 1950 when A.K. Gopalan, a communist leader, was arrested.
It takes another 3-4 decades before the things are changed. Okay, so in A.K. Gopalan case, the court says natural justice principles cannot be read into the law. Okay, and procedure established by law means if there is a law, that is all. That's the end of the story. Okay, and that there is no link between Article 19, 21, and 22.
So they say that 19, 21, and 22 are all watertight compartments. So when you're talking of 22, you don't look at 19 and 21. That's a separate article. You look at 22 separately. You can't invoke the rights under 19 and 21 when there is an order of preventive detention which is provided under 22. So that was the, because A.K. Gopalan said, even though I may be arrested under using Article 22, my rights under 19 and 21 will also have to be protected. And so you need to evaluate my detention order, keeping in mind the provisions of Article 19 and 21. So whether my detention is valid, it will also satisfy the test of 19 and 21. But this was rejected in A.K. Gopalan's case.
It took 20 years before the first change took place. Numerous cases went to the Supreme Court. All the cases were negative on the ground that if there is a law and that's a procedure, that law sets a procedure and that procedure is followed, that's the end of the story. You cannot question the might of the state. The first change came about during the bank nationalization case, okay, in 1970, when it's called Cooper versus Union of India, when the government of India nationalized 14 commercial banks, okay, and it went to the went up to the Supreme Court. Finally, the Supreme Court said that yes, there may be a procedure for nationalization for taking over the banks, private banks by the government, but merely because there is a law and a procedure, that is not enough. You have to look into whether it is fair, whether it is appropriate, etc. And then they come and the Supreme Court says there has to be compensation equal to the property acquired by the from the persons concerned. Now, what happened? Now you have to keep in mind, earlier preventive detention law was regarding personal life and liberty. But now the law changes because it includes property.
I mean, the law doesn't change, the interpretation.
Yeah, sorry, correct. I stand corrected. The interpretation of the same Article 20, 21, 22 changes now. When monetary interests come, when property comes, you know, that's when the law starts being interpreted in a different way. So keep in mind, we are now 20 years into the Constitution of India, 1950 to 1970. When does the next change take place?
So, I mean, of course, incidentally, 19(1)(f), which you must have seen that missing clause in the Constitution, the right to property was removed from the fundamental rights chapter thereafter, after the nationalization cases, etc.
The next change came about in 1978 after the emergency. One thing, Sendil and others, I would like to point out, even though the emergency was a dark period, let's not forget, hundreds of thousands of young people stood out to fight against the emergency, and eventually emergency was lifted and Indira Gandhi was defeated. So let's not forget the fact that people live by their conscience, have fought by their conscience, and have ensured that the Constitution is alive for us now to talk about it. So every time you feel fear, please keep in mind the thousands of people who defied fear to stand up because it was their conscience. Okay. Now in 1978, Maneka Gandhi, who was Indira Gandhi's daughter-in-law, she's now an MP. Okay, her passport was impounded by the Morarji Desai government of the Janata Party. Okay, and they were not giving it to her on the ground of interest of general public. This was then challenged by Maneka Gandhi in the Supreme Court. Supreme Court now suddenly wakes up. Now you remember personal liberty of a political activist like A.K. Gopalan, personal liberty and preventive detention of other political activists between 1950 to 1970. Supreme Court says will not look into it. 1970, the first change takes place when it comes on to property rights. 1978, the thing changed when the person concerned is a very elite person. Okay, so that's when they said that they overruled A.K. Gopalan in 1978 and came out with the thing that you can't look at 14, 19, and 21, like what Saila said, as watertight compartment. They are linked. Okay, so violation of liberty of a person will have to be looked at from the viewpoint of these three.
See, because
articles.
since Maneka Gandhi was not given her passport, so what was argued is her right to travel abroad, which is, you know, part of 19, which is at 14, 21, like your right to life. So all this is encompassed, so that one act of denying her the passport violates all these articles. And you have to read all of them together. Now you recall that in A.K. Gopalan, they rejected those arguments. Finally, in Maneka Gandhi, the court turns around and says, what was decided in A.K. Gopalan is wrong. So we are overruling A.K. Gopalan. And now we say that 14, 19, 21 are all interlinked. And even while testing something, an order which is passed under any law, you will have to satisfy the provisions of all these fundamental rights.
Okay, we'll have to go a little faster now. They
No,
basically
just 1 second. I just get this weird thought now. when a judgment is getting overruled, does it mean that they owe some compensation or some sort of other things for that judgment because they didn't allow some judgment at that time? The justice is not served then, right?
No, see, law keeps on evolving.
No,
And
judges, first to tell you, judges enjoy immunity for any actions because otherwise no judge can ever give a judgment. Judgments may be right, wrong. And like how Justice Khanna's dissent, he said it is for the future. So
Yeah.
sometimes it takes time, for even case laws.
For law to
principles
evolve
of
also,
law to evolve.
it takes a lot of time. It testing out in the courts. Every time you're testing it out before a new principle comes.
And as Suresh was mentioning, the emergency experience and the kind of criticism of the Supreme Court after the ADM Jabalpur judgment, people really, that was the darkest hour of even the Supreme Court's history. Even till today, people go back to that. And in fact, Justice Chandrachud, the Chief Justice Chandrachud, Dhananjay, who's just retired, he actually apologized to the people for the judgment in ADM Jabalpur, which his father was
He wrote
who wrote the judgment.
the key part. In fact, there's a saying, when the judges were asked to bend, they crawled. That's how the ADM Jabalpur case is described.
But the strong criticism that came, not only about the emergency, but the fact that the Supreme Court also buckled and gave in and did not stand by the people of India, that strong criticism also worked on the judges. When subsequently Maneka Gandhi's judgment, so it is not just about one judge this way or that way, it is also the history, the political engagement of the people. See, that is where the people's engagement becomes very important. If all of us are mute spectators, emergency could have continued, forever. So
just to give you another common example of how people's power and people's opinion matters, you all will remember about 2 years back, the judges gave a judgment of contempt against Prashant Bhushan, and they were about to arrest him. It is an atrocious ruling. We can discuss that at a later time. That time, countrywide, there were protests. People wrote back, people expressed their views about how this particular judge of the Supreme Court is actually taking out a personal vendetta against him, and how this is going to institutionally damage the court. Eventually, after about a week or 10 days of this type of a widespread protest against it, the Supreme Court backed off. And they just said about 100 rupees, some fine or something. 1 rupee fine, and they backed off. One more example, during COVID, when public interest litigation was filed by Harsh Mandar, talking about the difficulties of people who are forced to walk on roads thousands of kilometers back to their homes. The first time the Supreme Court, before the Supreme Court, the present Solicitor General said nothing. This is all a very biased and prejudiced view of a few people who want to bring down the name of the present government. You see, and the Supreme Court also refused to take that into action until the criticism.
Fact, the Supreme Court said, who asked them to walk? If they want to walk, let them walk. Nobody asked them to do it.
But then when the Petitioners Council said there's no way to walk, there's no transport, they said then they don't need to walk, let them be where they are. If you remember at that time during COVID, number of people were killed when they were sleeping on the railway track. Okay. The reaction again was the same way. Inside the argument of the central government at that time, who asked them to sleep on the railway track because they know train will come and they'll get killed. This is a callous attitude that we have now. I mean, the state now is with this type of a callous attitude, and the courts, unfortunately, are made up of human beings like you and me. So one level of thinking was saying, this is okay, this is natural. But the countrywide protest about the public outcry that came against the Supreme Court ruling eventually forced the same Supreme Court to back off and to take up the PIL on COVID. If you all remember that, it just happened within our times. Okay, just to tell you, therefore, the power of public opinion and the power of public expression of our rights is extremely important. We'll go back. So 1950, 1970, 1978, then things start changing. Now, the horizons of Article 21 start expanding based on the Maneka Gandhi case. Maneka Gandhi case was an extremely important landmark and historical timeline. It was an extremely important moment when they now start looking, like I said earlier, they start resurrecting and expanding Article 21 in the light of 14 and 19. 14 is equality, 19 are fundamental freedoms. Okay. And then subsequently, they also read into it the fundamental duties and also the directive principles of state policy. So let's see a few things. We've gone beyond time. Now, what has been the changes? What has been the expansion of Article 21 in the criminal justice system?
So if you see now, they have, when there's a police can arrest, there is a power to arrest under the Criminal Procedure Code. We have seen even in Article 20, etc. But the Supreme Court has now said that while you are arresting a person, you are actually violating Article 21. So you need to exercise, you may have the power to arrest, but you cannot exercise that power in a very arbitrary fashion, because one will have to weigh to see whether there is a need to arrest. So the power to arrest is one thing, but only if there is a need to arrest, you should actually arrest, because you are actually curtailing the liberty of a citizen, and in which case you need to be very, very measured in the exercise of that power. That it is largely abused is a different matter.
Since Supreme Court gave in 1994 in a case called Joginder Kumar, where one young lawyer was arrested by the UP police, kept hidden. Cases were filed in the High Court, eventually in the Supreme Court. There the Supreme Court said the police may have the authority to arrest, but whether there was a need to arrest has to be examined, and that can be judicially examined on three lines: whether the accused will run away and escape justice, or whether they will threaten the witnesses, or they will destroy evidence. Only if these three conditions are there, is there a need to arrest. So you can't, the police just cannot say, I have the authority. They have to justify their arrest. Eventually, the law changed subsequently, keeping in mind these things, and said that every time you're going to be arrested, written intimation should be given, relatives should be told, etc., etc. Again, that's a wider issue. But expansion of Article 21 has given us these extremely important rights vis-a-vis the police.
That is in your everyday criminal justice system. Now they have all fallen back on the rights given by the fundamental rights. For instance, bail, not jail, is a rule which the Supreme Court announced, saying, enunciated, saying that when a person who's arrested applies for bail, by and large, the rule should be to grant the citizen a bail, because generally it is arrest is a pre-trial arrest. That is, you have not yet been convicted. You have not, the evidence against you has not been tested. You have not been found guilty. So the rule is bail, and jail should become an exception. So that again, that principle has been carved out from Article 19 and 21 and 14. Then handcuffing and shackling of prisoners. It used to be routinely people are, handcuffed. And that was questioned. And then the Supreme Court said, see, merely because somebody is being deprived under 22, if you can arrest them, you may have the power to arrest. But that doesn't mean that the arrested person is shred of all the rights under the Constitution.
Including the right to dignity.
Because right to life doesn't mean just a dog's existence. It means a right to live with dignity. That was also expanded. And in that context, they say, you may arrest a person, but you still have to treat the arrested person with dignity, and you cannot handcuff and shackle a person unless you get an order of the court each time you want to do the handcuffing, which now it has changed.
Unfortunately, the recent changes to this Bharatiya Nyaya Sanhita, BNSS, they've changed this law. Until 2023, the law was that every time a person is handcuffed by the police and brought to the court, every time they have to get every single time they have to get a separate order from the court. Shackling is not allowed as a rule. It is happening not because it's a rule. It's happening because nobody is questioning these things. You will be surprised, even in Europe, even in America, the handcuffing and shackling is very routine. In India, it is not routine. It cannot be routine as per the law.
So similarly, legal aid is a right. Pre-trial detention is bad. Everybody is entitled to fair trial. Speedy trial. Now, all this having a fair trial, having a speedy trial has been linked to, again, Article 21, because a procedure established by law means a procedure which is fair. And when you say a procedure should be fair, it means your trial should be fair, and it should also be speedy, because you can't keep a citizen hanging for years on end without, being an under trial person and, being delayed by the courts. Of course, there's still a lot of delay happening, but at least that is not something which is sanctioned by law.
Speedy trial has been said to be a fundamental right. Okay. Now it's up to us to keep on demanding not just recognition, but that it is respected by the by the government. In prisoners' rights, solitary confinement cannot be given unless it is a punishment by the prison authorities for a prison offense. And that too, there are conditions. You can't give solitary confinement for more than 14 days at a time, once in 3 months, or conditions like that, depending upon prison rules of each state. Prison conditions. The court says, the Supreme Court has held in many times, merely because your personal, your right of personal movement is curtailed because you are arrested, that does not mean your other rights are curtailed. There are many fundamental rights which come to you, barring the right of free movement. Okay, so prison conditions, prison administration, overcrowding of prisons. Again, there's not much time to look at it, but expansion of Article 21 in the last 30 to 40 years has been very, very wide.
So the Supreme Court says that when a person is arrested and put in jail, at best you are curtailing his movement, the right to move freely into all parts of India, which is guaranteed under 19. But the rest of the rights, that is your right to equality, to be treated well in prison, to be treated equally. You can't discriminate between prisoners. Then to be treated with dignity, because Article 21 also travels beyond the prison walls. That's the language used by the Supreme Court.
Last 6 months back, you would have might have read in the papers, Supreme Court said Dalit prisoners are treated with discrimination in the courts, in the prisons, based on old antiquated British laws. If just 6 months back, this ruling came, asking all the state governments to relook the prison laws and not to discriminate between Dalit and non-Dalit prisoners. It's still an issue. So if some of you are interested in working on it, that's an issue that you can look at. Okay. Payment, and now we're just going to run through. We can share this PowerPoint with you all. Payment of damages and compensation. Courts have recognized that, Senthil, when you were asking earlier, that when persons suffer on account of illegal state action, then they are entitled to payment of compensation. For example, in custodial torture or in encounter deaths, etc. Now, these things are recent. When you look at it in terms of constitutional history, last 25 to 30 years alone, compensation has come about. They have also expanded it in other ways. For example, right to life includes.
So if you see the argument, right to life does not mean just living. Just I have a life, I'm able to breathe. So they say you can't give such kind of a restrictive meaning to right to life. Right to life means the right to live with human dignity. No, so everything that is required to live with human dignity is also encompassed within the right to life. So what do you require to live with human dignity? The Supreme Court has now expanded that right to say that your right to livelihood, because without livelihood, you cannot live with dignity. So livelihood is a part of Article 21. Right to clean water, right to clean air, right to health, right to food, right to shelter, right against sexual harassment, right to privacy.
Right to education.
All these things today the courts have held is part of Article 21.
Okay. We will, I think we'll just stop here because we have gone far beyond our time. Okay. This is about Article 22. Which talks about like what Saila had heard earlier, that you cannot be convicted for an offense more than one. Okay.
So we'll stop here, but this is just to give you an overview that law is ever expanding, ever, creating, and we don't restrict understanding of law to the mere letter. Constantly, courts are trying to see the spirit behind the law and expand the principles behind the concept behind every word to actually give life to the constitutional vision which is set out in the preamble.
Okay, just to conclude this part of the thing, if you'll remember, Arvind had said right in the first lecture that some of the most celebrated cases that went to the Supreme Court on human rights, on fundamental rights in the Constitution were not brought to the court by some very highly educated or very elite people. Ordinary people who went to the courts. You'll remember that case that Saila had talked about in the first lecture about how a prostitute, or rather a sex worker, had gone to the court in the 50s to file a case in terms of the rights of sex workers to live with dignity. So that's a point that we need to keep in mind. This whole idea of this series is to say that we as ordinary people, once our understanding expands, we have within us the possibility of going to the court every time we come across a situation where our fundamental rights are violated. Okay, that's the spirit with which we are conducting these discussions. And we hope that you will also take that spirit with you whenever you're looking at issues in and around you.
So because again, this is not only in respect of criminal law or anything. Now, these principles of having a fair procedure, is now in every aspect of life. Even if it is an employment law, if an employer is dismissing a worker, now are they being fair in doing it? So all these principles have been, read into many other everyday provisions of law, whether it is contractual law or, employment law.
Okay.
So we'll stop here. It's really late today.
Today
So
we've
any
expanded time.
questions before we wind up?
Yeah.
There's one question by Satya. Do the states pay compensation in case of encounter deaths?
If it is proved that it's an encounter death, yes. Recently, there is a case that
I think Tamil
2
Nadu
days,
High Court
no,
has
2 days back, there is a
Madras High
case.
Court has given. Bharat Chakravarti.
Yeah, in Madras High Court, there was a ruling given about end of November, where they have granted compensation of 10 lakh rupees to the mother of a person who was killed in custody. Okay, so there are some. It's very few and far in between, but there are examples.
No, in fact, these days what is happening is, while sometimes the state themselves are very proactively ordering compensation, but still, I think paying compensation itself is not sufficient. What we are demanding is accountability. So because you can't kill a person and say that it can be settled with money, because it is a high-handed state action, which they have no business to indulge in. And I think despite whether they pay compensation, yes, but beyond that, they need to be made accountable for their acts.
Ujjwal has a very important question. Does the prolonged lockdown in Jammu and Kashmir during the abrogation of Article 370, along with detention of advocates, activists, and political leaders under the Public Safety Act, amount to violation? We would say yes, undoubtedly, Ujjwal. Ujjwal, that's a very, very good question you have asked. And for the benefit of all others, Ujjwal is a young law student studying in Baroda, whom we had met some time back. It's a wonderful question, Ujjwal. Yes, it is. See, this is where Supreme Court has not yet brought those habeas corpus petitions from Kashmir. There's no from when was it? 2019, when Article 370 was abrogated, and many people were arrested and kept inside, and habeas corpus petitions were filed. Since then, that's 7 years, 8 years now. No, 6 years. Those habeas corpus petitions have not been taken up for hearing in the Supreme Court.
So if you see, the right to speedy trial is a
fundamental right.
Part of Article 21 is what the Supreme Court said, and how by delaying even hearing of the case, or even we are seeing the bail petitions, bail applications of Umar Khalid, it's ridiculous.
5 years now. For 2.5 years, they've been hearing. Each court is putting it on to somebody else. Vinuta, you had asked the question of habeas corpus. I hope you're still around. Habeas corpus means produce the person alive or dead. So it goes back to 17th century England, when the ruling government of that day would do anything with its people. So they went to the courts at that time and asked the court to pass a writ. Writ means a direction to the police of that time to say, bring this person alive or dead before us, so that we need to satisfy whether the person is alive or dead. So that's a very important fundamental right that's been given to us. We will look into this later, but a writ of habeas corpus means when somebody is missing, somebody's been picked up by the cops and taken over, or various other questions where you doubt whether the person is alive or not, you can go to the court and ask the court to direct the police and the state to produce the person.
And you can approach both the High Courts and the Supreme Court.
And the Supreme Court. So that's the writ of your habeas corpus. So Ujjwal, your question that habeas corpus petition is still pending. Unfortunately, public opinion is not rising about these questions. So Senthil, your question about what can we do? We need to continually keep asking questions, seeking accountability, including from the Supreme Court.
And the first step to that is to learn the language of the Constitution, to learn to think in the language of the Constitution. I think today that is being forgotten even when we are arguing in courts. Because in courts today, when we file a habeas corpus petition, habeas corpus is when when you fear that a person is being illegally detained, confined by some power. And you'll find the courts routinely saying, okay, order, notice 2 weeks, counter after 4 weeks. Is that the urgency with which you deal when the personal liberty of a person is under threat? So it has become so normalized, and they have become so mechanical, because somewhere we have been numbed to the very important core constitutional principles which are embedded in these very powerful powers that have been given to the constitutional courts. Because the writ of habeas corpus is only given to the High Court and the Supreme Court. So the judges have totally forgotten that the Constitution has given them this power for a purpose. to protect the citizens and not become so insensitive that you treat a habeas corpus petition in such a routine manner and tell, okay, take notice, you can file a counter after 4 weeks, and then the public prosecutor will come and say, I couldn't get it signed, give me another 4 weeks. And routinely such adjournments are being granted because even in court halls, we have forgotten the language and the spirit of the Constitution.
Okay, I think we'll have to
With that, we'll call
put a
it a
hard
day.
stop. We'll call it a day. We would like you all to write back to us because we are now halfway through the whole course.